Hi, y'all, and welcome to tonight's live stream. For those of you who are wondering, what is going to be the huge case of 2025? What's going to be the biggest true crime case? Well, the answer is, surprisingly enough, not going to be Brian Kohberger. That's going to be huge. That's going to be a really important, very large case. But I'm convinced the most talked about trial of 2025 is going to be the Vallow Daybell case. As of yesterday, we learned that she is deemed competent to stand trial. I'll go through what that means. We'll talk about it. I'll play you a little clip from the hearing. She today was deemed competent enough or she was deemed able to represent herself. So Vallow Daybell will be actually representing herself at trial. Are we headed for Darrell Brooks 2.0? What could possibly go wrong in this scenario? That's what we're going to be talking about tonight. So a brief overview of the case for those of you who might be new to it. Vallow Daybell is infamous for already having been convicted of murdering her two children, JJ, age 7, and Tylee, age 16, and her lover, soon-to-be husband's wife, Tammy Daybell. Vallow Daybell then married her lover, Chad Daybell, who currently sits on death row, also convicted of the very same things Vallow Daybell was convicted of. Vallow Daybell and Chad then married after his wife was out of the way, and so they are now a couple, but separated, of course, in different prisons. But before any of those three people were murdered, there was another murder. Charles Vallow, Lori's husband at the time, was shot by her brother, Alex. And someone driving Tylee, her daughter's Jeep, shot at Lori's nephew-in-law, Brandon Boudreaux. Authorities again think that was Alex, Lori's brother. And they think Vallow Daybell was behind both murders. She is accused in Arizona of the attempted murder of Brandon Boudreaux and a murder conspiracy for the death of her her husband at the time, estranged, Charles Vallow. Now, she wanted to represent herself at trial, but her lawyers objected, and her lawyers thought she should be evaluated to see whether she is mentally competent. She got new lawyers who argued for her that she didn't need to be evaluated, but the judge said, I want an evaluation anyway. So tonight we're going to cover three topics. First, why the court found her competent, what that means, and why. Why the court says she can represent herself, and what it's going to mean for Vallow Daybell and for the not one, but actually two trials that are coming up. Now, I want to say a special shout out to the first 5 in the chat tonight. Jan S., Maya Rodriguez Sorensen, who also has an Esquire, but is an actual Esquire. I put Esquire on the thumbnail for this video. Vallow Daybell does not become an attorney just by representing herself. I was just pointing out that she's going to represent herself. Bupsy, Michael Lalonde, and Lee T. So welcome. Special shout out to the first 5 of you to leave a comment in the chat. Now, there's something brand new in the description to this video that you may have noticed. I listed books for kids. I asked about this past summer. I was visiting my grandkids who are really little, and I asked for what are some good books I can read them, because I was having a really great time reading to them. And y'all came up with a list. So this is the Lawyerly subscriber approved list of books for young kids. And I've done links to Amazon. Those are affiliate links, so I'll receive like nothing basically, but something if you order that. Mostly I just thought it was really cool because these are books that you think are great. So if you're buying gifts for your grandkids or kids this Christmas, I thought you'd want to know some great books to buy them. I personally plan to buy out that list for mine. So, okay, let's get into the court finding her competent, finding Vallow Daybell was competent. Now, I'm going to show you a clip toward the end of our talk tonight. I'm going to show you a clip that, let me fix that. Sorry, that's driving me crazy. Okay, there we go. All right, so I'm going to show you a clip from Vallow Daybell's sentencing hearing in the case in which she was convicted of murdering JJ, Tylee, and also the ex of Chad Daybell, Tammy Daybell. So I'm going to show you a clip of that. from that and for other reasons, many people think she is at a minimum highly unstable, if not completely crazy. So the question is, why was she found mentally competent? What does that even mean? And why did it happen? So let me show you first a slide. This is a rule. Well, first I'll show you the Sixth Amendment. It says there's one part of it I want to show you, and we'll talk about this in just a second, that in the United States, you have the right to have the assistance of counsel for his defense. That's a right that all of us have, to have the assistance of counsel in defense of ourselves. In this particular case, the courts have interpreted that to mean that you have the right to have the assistance of counsel, but you don't have to have it. Kind of implied in this is you have the right to do it if you want to, but that you also don't have to do it. Well, let's take a look. This is the Arizona Rule of Criminal Procedure, and it talks about what is incompetence. Incompetence means a defendant is unable to understand the nature and objective of the proceedings or to assist in his or her defense because of a mental illness, defect, or disability. A defendant may not be tried, convicted, or sentenced while that defendant is incompetent. A defendant is not incompetent to stand trial merely because the defendant has a mental illness, defect, or disability. So it's a pretty high standard. In order to meet it, the defendant actually has to be unable to assist with his or her defense because of the mental illness. It's not that the person has a mental illness, that the person has delusional thoughts. It's that they can't assist in their defense because of what's going on with them mentally. So let's go ahead and take a listen to the hearing yesterday in which the judge explained why she's being deemed competent.
Last we were here, we were waiting on a second report from Dr. Hernandez. Since that time, Dr. Hernandez has been relieved. The court's appointed Dr. Webster. Dr. Webster has met with the defendant and submitted a report dated December 2nd, 2024. So we do have two reports. Redactions are allowed for any statements by the defendant about the charged offense or any other charged or uncharged offense or any summary of such offense. I read that to be very broad, but I don't read that to include anything outside of statements about those things. The court is not yet in receipt, but will be in receipt of a stipulation as to the defendant's competency based on the written reports here by Dr. McGady, dated November 7th, 2024, Dr. Webster, dated December 2nd, 2024, stipulation having been accepted, the reports having been considered, the court finds the defendant understands the proceedings, is able to assist counsel in her defense. The court further finds the defendant competent pursuant to statute. So last we were...
Let's stop it right there. And oh, nope, that's totally fine. Let me remove that and make this a little bit larger. So what the court found was that she was competent to stand trial. In other words, that she met that very low standard of being able to assist with her defense, that she was able to do that. Two doctors evaluated her. That's the requirement under the criminal rule within Arizona. And two doctors found that she was able to understand the nature and objective of the proceeding. She was able to assist with her defense. And that's all that was required. They didn't have to decide she had no thoughts that were strange, erratic, bizarre. That none of that was relevant. All that mattered was that very low standard. And the court said, look, we've asked two doctors, and the doctors think you're just fine for purposes of being competent under the statute. So for that limited thing, they think you're just fine. So that is a different question, although frankly not a lot different from whether or not she could represent herself. It's a different question, and a different court answered that today. And today the court found that she did have the right to represent herself. Now I want to show you very quickly the Supreme Court case that talked about why that is. So let me head over here to the Supreme Court case. It's Ferretta v. California from all the way back in 1975. And it said the Sixth Amendment is made applicable to the states by the 14th. That's what we just looked at a minute ago. Guarantees that a defendant in a state criminal trial has an independent constitutional right of self-representation, and that he may proceed to defend himself without counsel when he voluntarily and intelligently elects to do so. And In this case, the state courts erred in forcing petitioner against his will to accept a state-appointed public defender and in denying the request to conduct his own defense. Now, this is actually especially for those of you who are lawyers, this is actually the syllabus. So it's a sort of like a summary, a synopsis of what the court said. Let's look at the actual case itself and what the Supreme Court said. It said, the question, in other words, what they've been asked to answer, whether a state may constitutionally hail a person into its criminal court and there force a lawyer upon him, even when he insists that he wants to conduct defense. It's not an easy, but we have concluded that a state may not constitutionally do so. So in other words, Arizona is not allowed to force Lori Vallow Daybell to have an attorney if she conduct her own defense. That's actually a constitutional that she has, according to the Supreme Court. I'll skip that one. Undeniable that most criminal prosecutions, defendants could better defend with counsel's guidance and by their unskilled efforts, but where the defendant will not voluntarily accept representation by counsel, the potential advantage of a lawyer's training and experience can be realized, if at all, only imperfectly. We'll talk about what this means. It's kind of tough language. To force a lawyer on a defendant can only lead him to believe that the law contrives against him. Moreover, it's not inconceivable that in some rare instances, the defendant might, in fact, present his more effectively by conducting his own defense. So what the court is saying there is, the reason we do this is that we believe that lawyers are going to help the defendant. But if what we do is force a lawyer on them, then we undermine the whole point of it, because the person is going to be skeptical. They're not going to be convinced this person has their best interests at heart. So that undermines the reason that we value and use attorneys in our system. And it said, well, it could be that the person would do a better job than the lawyer would. We'll talk about that in just a minute. The defendant, and not his lawyer or the state, will bear the personal consequences of a conviction. It is the defendant, therefore, who must be free personally to decide whether, in his particular case, counsel is to his advantage. And although he may conduct his own defense, ultimately to his own detriment, his choice must be honored out of that respect for the individual, which is the lifeblood of the law. And we see that so often in cases and in the rulings around them, that the individual is super important. And that's one of the bedrock, most important fundamental ideas within our judicial system. He should be made aware of the dangers and disadvantages of self-representation. Record will establish that he knows what he's doing and his choice is made with eyes open. And you're about to see the court. I'm going to show some clips to you. You're going to see the court run through a series of questions with Lori Vallow Daybell. And it's exactly for this reason, so that the record will establish that she knows what she's doing and that the choice is made with her eyes wide open. Although a defendant need not himself have the skill and experience of a lawyer in order competently and intelligently to choose self-representation, he should be made aware of the dangers and disadvantages of self-representation, so that the record will establish that he knows what he's doing and his choice is made with eyes open. I think that was the same sentence I read to y'all. Sorry about that. So what we see in that is that we are now going to watch the court ask Lori Vallow Daybell a series of questions. You're going to see that Supreme Court case sort of brought to life in Lori Vallow Daybell's case. Here it is.
Found competent by two separate healthcare providers. Is it your intention, ma'am? You had expressed earlier that you would like to represent yourself.
Yes, sir.
Is that still your intention?
Yes, Your Honor.
You do understand that you have the right to have attorneys represent you during your cases?
I do.
What grade did you finish in school?
I graduated from high school.
Do you read and understand English?
I do.
Have you had any alcohol or medication in the last 24 hours?
No.
Are you currently prescribed any medications in the jail?
No.
Do you believe you're able to present a defense at trial?
I do.
Are you able to listen to what the court, counsel, and witnesses say during trial?
Yes, I will.
Do you believe you're able to ask witnesses questions that are relevant to the case and to your defense?
Absolutely.
Are you able to communicate effectively, do you believe, with the court, counsel, opposing counsel, and the jury?
I do.
I will make a finding that in court you do appear to act appropriately, speak appropriately, and communicate appropriately. Have you ever represented yourself before?
Not yet.
And
So you can see he's asking her all those questions to be sure that the record is very clear, that she knows what she's doing, that she's able to represent herself, or at least understand that what she's doing and why she's choosing it, and to clearly state that she wishes to choose this. He's running through all that. He reminds her she has the right to an attorney, and he reminds her of what's at stake. But she is nothing if not confident.
attorney can be of great value and assistance in criminal cases. There are serious disadvantages and dangers to representing yourself. Can you just tell me a little bit why you want to represent yourself?
Yes, Your Honor. For the past 5 years that I've been incarcerated, I have taken it upon myself to study case law and criminal rules of procedure in the state of Idaho and Arizona, as well as federally. Prior to that, for the last 10 years, prior to my incarceration, I did study procedure in family law, and I have real trial experience. I have participated in 3 different full trials from beginning to end.
In family court?
1 in family court, 2 in criminal court, 1 bench trial and 1 jury trial.
It's hard to argue with that. Who has more experience with murder trials than Lori Vallow Daybell? She actually has done more than probably most attorneys have done. She's had 3 different, well, it was 1 trial, but 3 different murders she was charged with. So she's saying, look, I know all about this. I'm an experienced criminal defendant. Who better to know exactly how to handle a murder case? So that's her argument. She's saying, I'm just fine with this. I've also done family court. I've seen trials. I know exactly what I'm doing. So the judge tries to warn her about what the consequences could be.
Okay. You understand that you have 2 separate cases here. On each of these cases, if you're found guilty at trial, you'd be facing a sentence of up to life in prison with the possibility of parole after 25 years?
Yes, I'm well aware of that.
And you understand that if convicted at trial, that those sentences could run consecutively or concurrently to any other sentence?
I am also well aware of that.
You understand that if you represent yourself, you'll have the sole responsibility for, among other things, asserting legal defenses, interviewing witnesses, doing investigation, doing legal research, filing and arguing motions, examining and cross-examining witnesses, giving an opening statement and a final argument to the jury. Do you understand all that?
Yes, Your Honor, and I'm very prepared.
All right. Do you also understand that you'd be held to the same standard as an attorney regarding the presentation of your case? This would include knowledge of courtroom procedure, applicable case law, rules of evidence, and rules of procedure?
Yes.
All right. Each of your attorneys have gone to college, undergrad degree for probably a minimum of 4 years, and then law school for an additional 3 years. So these 2 attorneys that are here in court each have, at a minimum, if not more, 14 years of higher education, as well as probably, I'm guessing, between the 2 of them, 30 to 40 years in trial experience. Do you understand that?
Yes.
Do you understand that your case may be specifically complicated in the sense that there are complicated evidentiary issues in your case? Do you believe you're able to present a defense?
Yes, I'm well aware of them.
But I will just say this, she's not. She's not well aware of them, because she is not going to be able to make the right objections at trial. She's not going to know when the evidence is coming in improperly or should be done a different way, even. If she's not going to be able to learn all of those evidentiary objections within the amount of time she has left. So what's going to happen is she's not going to object to a lot of things that might be objectionable. And the one thing I think she probably might believe that her counsel at her former trial, her former murder trial, really didn't do a lot for her, that she can't do a lot worse than they did. They did very, very little in terms of their presentation to the jury. They asked few questions, they put up few witnesses, and maybe she feels like I've got this, I can do better than that. But the problem is that the system isn't really set up for this. Even though it's a right that the criminal defendant has, the system isn't set up to bring in somebody who doesn't really understand the rules. There's no back guard on it. There's nothing to say, oh, here's where this person is messing up and isn't getting an objection in. It just won't happen.
Do you also understand that if at some point, especially if you're in the middle of trial, you decide that you would like your attorneys to take over the case, you'd be effectively waiving any ineffective assistance of counsel claim that you might have because they might like a longer time to prepare?
Correct.
Do you understand that even if I may allow you to represent yourself, I'll be appointing these attorneys to represent you as advisory counsel?
That's my understanding.
So he's just throwing out every possible thing that she might argue later almost surely through counsel when an appeal is done. Maybe she would say, well, I called in these attorneys, but they weren't prepared. And the judge is saying, look, it's going to be natural that they're not going to be prepared because we're going to be calling them in the middle of trial. So she's also, he did explain something to her. I thought this was just interesting.
If you want to testify at trial, you'd not be able to testify in a narrative format. Instead, you'd need to write out the questions, and the advisory counsels would ask you questions when you testify.
Yes, that's what I'm aware of.
So it would be different, for example, from what happened at the Robert Tellis trial that we covered, where he just got up there and gave a narrative. She actually has to write out the questions. And so the advisory counsel, not her actual lawyers, will stand up there and ask her the questions. And then she'll answer the questions that she herself wrote for her. So she can change her mind at any time, but she only gets to do that once.
You can change your mind about this at any time. If at any time you want to be represented by your advisory counsel, let me know. I will appoint them back to represent you as your attorneys of record. But once you make the choice to have the lawyer represent you again, I wouldn't allow you to switch back and forth. Because you'll be acting as your own attorney, you'd be expected to appear for every court hearing and every day of trial. If you do not appear for hearings or trial without good cause, I could consider your non-appearance to be an indication that you want to withdraw your right to represent yourself, and I would order your advisory counsel to become your attorney. Do you understand that as well?
Sure.
Your right to
Let me stop it there for a second to say a couple of points about that. First of all, this was sort of a shot over the bow because she didn't show up for her most recent hearing. And it's not the only time that there's been complaints that she wasn't showing up. So he's saying, we're not going to proceed without you, and you have to show up. You can't just decide today I'm not going. So that was a shot over the bow saying you're going to have to show up. Also, the fact that she's being told that once she makes the choice, she's stuck with the choice. I don't know whether he would actually in the end enforce that, but that is what he's telling her, that if she starts to represent herself and then says, no, I want to go back to counsel, he's saying, I'm not going to let you go back and forth. That will be your last chance.
That yourself is not absolute, and what I mean by that is if you fail to follow procedures, if you don't act appropriate in the courtroom, your right to represent yourself could be revoked. Do you understand that as well?
I do understand that.
I want to say something about this. In fact, I'm going to pull out for just a minute because this is a stark contrast to what actually occurred in the Darrell Brooks case. In the Darrell Brooks case, he was absolutely disruptive to the system to the extent that the judge repeatedly had to remove him to a different room, repeatedly had to just take him out, send him into a different courtroom entirely. They locked the doors, had a guard with him because they could that way turn down the sound on him so they could keep the proceedings going. And then they would turn it on if he had something to say and it was an appropriate time for him to say it. It was unbelievably disruptive. It was, to me, a mockery of the system. To me, that should not have been permitted. The judge should not have allowed that to happen. And regardless, there should have been some kind of ruling from her and just let it be tested by the appellate courts that if someone is that disruptive, if someone refuses to participate in the system as it is set up, that person can't continue to represent themselves. And in that particular case, the judge bent over backwards to allow Darrell Brooks to continue to represent himself. But I personally felt like it did go too far. Let me add this back.
The court finds your waiver to an attorney is knowingly, intelligently, voluntarily made. I guess I should ask you, did anyone force you or threaten you to waive your right to an attorney?
No, quite the opposite.
Did anyone promise you anything in order to get you to waive your right to an attorney?
No.
All right, I do find your waiver is to knowingly, intelligently, voluntarily made. Your waiver is accepted and entered of record. You will be your own attorney on the case. My understanding is there's a large amount of discovery.
So let me hold off on that for a second. So he set trial for March 31st for jury selection. Charles Vallow, as I understood it, is the first case. Then a separate case for Brandon Boudreaux will go forward, but they haven't even set the date for that. The first case out of the box will be March 31st, and then the second one will be set at some later date. Now, the court appointed an investigator to help her, or said he would appoint one, and also asked her, are you sure you don't need more time?
You're sure that you're going to be ready in time for March 31st?
Yes, Your Honor. Also, I have a reply to the state's response. I know that we said if you were to let me go pro per, that I would have 3 days to make this response, and I have a copy for the court and a copy for the state.
You've been found competent.
So let me remove that. And so she is ready there. She's got her assignment ready to go. It reminds me of, something out of high school. Oh, you wanted my assignment in. I've got a response to their brief and it's ready to go. I want you to know I haven't been sitting around. I'm ready to represent myself. And here's my very first pleading in proof that I'm actually ready and going to do it. Now, she called herself very prepared. She said she had, quote, real trial experience. And like I said, you can't really argue with that. She's already been present at a murder trial, for example. So she said she studied family law for 10 years. She feels totally ready for this. So just how bad could it be? We're about to explore that. I want to say thank you to a few people. Michael, thank you for that. And I appreciate your email very much. And Cutley, thank you very much for your super chat. I appreciate that. And Annie K has, in fact, been a member since the very first day of membership. So we are delighted to have you in the chat today and to have you back. All right. So are we headed for Darrell Brooks 2.0? Now, in some ways, no. And in some ways, I think it's going to be even worse than Darrell Brooks. Now, Darrell Brooks was very disrespectful, spoke out of turn, was rude, spoke over everybody, and like I said, spent much of the trial in a separate room where the volume could be turned down so that other people could have their turn to say whatever was appropriate. So I don't expect any of that with Lori Vallow Daybell. She's not going to be disrespectful. She's not going to talk over other people. But could it be bad? Oh, yes. Oh, very much yes. Here is a video clip from her sentencing hearing, which is the last time we heard her speak on this subject. Here it is.
Christ knows that no one was murdered in this case. Accidental deaths happen. Suicides happen. Fatal side effects from medications happen. I have a different perspective in life because in 2002, when I was pregnant with Tylee, I died in the hospital while in labor with her. I later returned to my body. Because of this experience, I have access to heaven and the spirit world. Since then, I have had many communications from people now living in heaven, including my children, Tylee Ashlyn and Joshua Jackson, my sisters, Stacy and Lolly, my aunts and my uncles, and my grandparents. I have had many communications with Jesus Christ, the Savior of this world, and our heavenly parents. I have had many angelic visitors have come and communicated with me and even manifested themselves to me.
So what we are going to see is going to be pretty different, I think, from what we saw with Darrell Brooks. It's not going to be her jumping up and interrupting people and just acting out in the courtroom. Instead, I think, and arguing with the judge, instead, we're going to see more of this very disconnected, strange talk and strange questions and strange arguments, because I believe this is her current worldview. And for example, and at the time she made these statements, she was deemed competent then too. She was able to understand what was happening at the trial. She was able to understand and assist her attorneys in representing her in that murder trial. So she doesn't have to be in any different condition than what you hear here in order to go forward with this trial and even to represent herself. So, and I do want to say one thing too, the statement she made about accidental deaths and so forth, that contradicts what she then told her son, Colby, after the trial in a recent interview. She said it was Tylee's fault, that Tylee actually killed JJ. So there is a little disconnect there. She also claimed in that speech she did during the sentencing for her Idaho trial that she has received visits from the 3 people she was convicted of murdering, that all of them totally understood. They reassured her she hadn't done anything wrong. They were all much better off where they were. Let's go ahead and hear what she had to say about
Visited
that.
me. She is happy and very busy. Tylee is free now from all the pains of her life. One of the times that Tylee came to me as a spirit after she died, she commanded me and she said to me, "Stop worrying, Mom. We are fine." The first time JJ visited me after he passed away, he put his arm around me and he said to me, "You didn't do anything wrong, Mom. I love you. And I know you loved me every minute of my life." He is busy. He is engaged. He has jobs that he does there, and he is happy where he is. My eternal friend, Tammy Daybell, has visited me on several occasions. She came to bring me peace and comfort, and I know that she is extremely busy helping her family, especially her children and grandchildren. And I have a great love for Tammy.
Now, that last was probably the most offensive of all the statements that she made because, of course, she was being convicted of murdering someone she had never met and who was married to the man that she married just 2 weeks after Tammy Daybell died. And so that was especially difficult for a lot of people to stomach because that statement suggested that she and Tammy were friends and that Tammy forgave her and thought this was all fine, had visited her on several occasions and was very happy in heaven. So that's the kind of thing I think we can expect. What is the result going to be? How is this going to change the trial? And the first thing I want to say is I think this will be a spectacle of major epic proportions, and it's going to be a significant headache for everybody involved in the actual trial itself. When you think about it, the judge has to constantly be thinking about appeal. The prosecutor has to constantly be thinking about appeal. How can they make sure that Lori Vallow Daybell is receiving a fair trial when she doesn't know what she's doing, when she has a lot of misconceptions, a lot of difficulty understanding what's actually happening, but she's permitted under the law to represent herself? How do they guard against an appeal? So that is something everybody there is going to have to be thinking about nonstop, is how do we protect this record so that we try the case only once and the result we get is the end result. So it's also going to create problems because there's going to be a lack of knowledge of the rules. She's not going to know a lot of the objections. It's unlikely that she'll make a lot of objections. She won't know when, she'll miss them. It could make a difference then on appeal. It's going to be extremely difficult too for the victims because the victims are going to be cross-examined by Lori Vallow Daybell, attorney, and not real attorney, but attorney for a day, if you will. And she's going to be allowed to cross-examine Brandon Boudreaux when he gets on the stand, Kay Woodcock when she gets on the stand, and probably other people, whoever gets called at trial. That is going to be an extremely awkward, uncomfortable event for the people who are testifying who believe she murdered their loved ones. It's just very difficult. It's going to be an awkward, terrible situation from their point of view, from the victims and victims' families' point of view. It's going to be hard for Lori Vallow Daybell also to do just some of the practical things she's going to need to do, like get witnesses. serve subpoenas on witnesses. So the attorneys will, I'm sure, help her, and an investigator was appointed to help her, but just it's practically speaking going to be hard for her. The cross-examination, when she gets to it for the various witnesses, is going to be wild because she knows these people personally. She knows their histories. They have history with each other, and they know her personally as well. So for the ones who are actual witnesses related to the events, as opposed to, say, law enforcement, she's going to have personal information, and it's going to be very difficult to control during cross-examination about what gets asked and what comes in. That'll be a challenge for the judge. I think we can also expect a lot of tangents, just like we saw in her statement during the sentencing hearing. I think we can expect tangents with questions that will seem irrelevant to most of the people in the courtroom, but that will have some coherence with her theory about what happened. And so there's going to be a longer cross-examination while she tries to get into areas that the judge is going to be unsure are even related. And then finally, I think appeal is an issue because everybody has to constantly be thinking, how do we keep this from being an appeal issue? How do we make sure that we guard this particular trial and the results here, and we don't have to do anything to protect it afterwards? We don't have to try it again. In other words, we don't have to ever do this again. We want to do it one time. We want it to be done. Let me say thank you to a couple of people, and then I want to talk for just a minute about how I believe this could really hurt Lori Vallow Daybell, and we'll talk about that in just a second. So Michael asking me if I liked the video with the coin-operated horses. You know, we had a coin-operated horse at the grocery store near our house. I never rode on that, but I always thought it looked really, really fun. Just those little, I don't know if you remember, they're little merry-go-rounds that used to be outside at least our grocery store. And Shard's words, thank you. And I'm so sorry you can't join from the iPhone. It's very annoying. I think there's some kind of dispute between YouTube and iPhones, but you can join if you go to the Safari browser. But anyway, thank you very much. I appreciate that gesture. Thank you for doing that. So how is this going to hurt Lori? Well, ironically, there is not a lot of evidence in these two cases to link Lori to the crimes. That's not to say there's not enough. I'm just saying there's not a lot. And maybe an attorney could have made a difference for her. I think it's going to be very hard for her to make those same points. Maybe, but I think it's going to be hard. When you look at the Charles Vallow case, all of the people present at the time either are deceased, like Charles Vallow, or and now Alex and Tylee, or told law enforcement that it was self-defense at the time. Alex, Tylee, Lori all said, "Hey, it was self-defense. He had a bat." Alex had no choice. There's no argument that Lori herself did anything to Charles Vallow, but that Alex did kill Charles Vallow. So that's the argument that they're making. Now, there are various facts like that will be thrown in there, things that she said, contradictions she made, but just saying there's less evidence than in some cases. They obviously believe they have enough to go forward with trial, and we will find out probably even more when we get to trial. As far as the Brandon Boudreaux case, there was the fact that there was a seat removed from the back of Tylee's car, and there's video of Chad and Lori putting that seat into their storage unit. Authorities have traced Alex, headed down there, but again, Brandon Boudreaux has identified the vehicle that was just like Tylee's and that he thought maybe was Tylee's as sitting near his home, and someone shot him from that vehicle. But there's not a ton of evidence against Lori herself. So these are cases where a defense lawyer might have been able to make some inroads, suggesting, well, maybe Lori wasn't involved, maybe Alex was the one who did all of this. But the fact that she represents herself is just going to increase the risk that the jury is going to find her very bizarre, frightening, and will convict her. So she is not going to have the protections of a lawyer to point out, here's a problem, there's a problem, here's a lack of evidence. She's going to have to do all that on her own. And I think it's going to be an absolutely wild ride. I think it's going to be a remarkable trial, one not to be missed. I don't know whether it will be broadcast. I hope so. The hearings have been broadcast on delay. I don't know how that would work in terms of a trial, but in any event, I don't know for sure. Oh, Harry Potter's beard is a new member. Welcome. We are so glad to have you. If you have some questions, go ahead and put those in the chat right now. And if you would put question marks at the beginning, that'll help me spot your question in the chat. So put more than one question mark if you would, and that'll help me spot it in the chat. And we'll do just a few questions from people. I think this is going to be an unbelievable trial. Just one for the one to be watched, one not to be missed. It's going to be remarkable. Tennis girl asking me, will she have attorneys available to consult with her? Yes, the judge is appointing attorneys to consult with her. He's appointing some counsel who will be responsible for doing that, but they will not technically represent her. They won't be able to speak for her. They won't be able to ask questions for her, but they can't answer questions and so forth. Leo Wren asks, am I going to attend? I am seriously considering attending. I'm seriously considering. One of the questions I have is whether it's going to be broadcast and what exactly that means, but I'm thinking very seriously about attending because I think it's going to be quite the trial, quite the trial. Denise wants to know if she's up for the death penalty. No, she's not. There is no attempt to make this a case like a capital case. Will Lori Lee T asked me be able to subpoena people to testify? Yes, she will be able to do that. I don't know exactly how they do the brass tacks. There's a lot to it, and you have to have somebody to serve it. So I assume the investigator and the counsel will help with all that and help her figure out how exactly she does that. There will have to be some funds allotted to her to pay a process server to take the subpoena out. Then you have to tender fees, witness fees when you give the subpoena to someone. So all those things are going to happen. So Maria Z, can you subpoena a spirit? I think not, but who knows? Maybe they could be served inside the portal in the closet. Do jail cells have closets? I don't think so. It could be a real problem. So I don't know that they'll be able to deliver those subpoenas, Maria Z. Yes, please question marks beforehand, and that will help me spot your chat. Sunset gazing. Will the trial be televised? I would like to know that. Is she doing this to take jabs at Kay or Colby? Does she have delusions of grandeur? I honestly do not know why she would do this sunset gazing. It's completely a bad idea. It's a really, really, really add some really's a bad idea. On the other hand, I think in the end, does it really matter? She's probably going to be convicted anyway. The thing about it is this particular case, there really is less evidence. If she were to have a chance of getting away, getting an acquittal, it would be in this case as opposed to, say, the Idaho case, because the evidence is less here connecting her directly, and less that in this particular case, it wasn't self-defense. It's just those are going to be arguments that somebody has to make. I did feel like, though, she may be frustrated with the level of representation she got in Idaho because her attorneys did not ask a lot of questions, get a lot of witnesses. There didn't seem to be a real push on her behalf, and she may have felt like, I can do just as well. That may be what she's thinking. Is she doing this to take a jab at individuals? She might really enjoy the opportunity to ask some questions. She may have multiple agendas behind some of this, such as, I'd like to tell them blah, blah, blah while I'm asking them questions. But a lot of that won't work out for her. She won't be allowed to ask some of those questions that she may have in mind. I just don't think that's her entire intent, is to just get at people. I don't think that's it. I can't explain it, but it may have just put her over the top in terms of her wanting this when her counsel thought that maybe she needed to be evaluated yet again for competency. I can't explain it. I really am mystified by it. If you know, please put it in the chat. I don't know the answer. In his will, could Chad be called as a witness? So in theory, yes, he is out of state. So there would have to be The subpoena would have to be domesticated, or there would have to be some kind of agreement. But yeah, he could be. Is Chad going to testify? Maybe she just wants to exchange with Chad their new prison portal pass. Sunset gazing. Well, that could be. I don't know. Maybe that's what it is. All right. BS. Will the jury know her convictions in Idaho? I don't know the answer to that. They're going to have to. I don't know the answer. It's often the case when someone has been convicted of a crime that reflects on their ability to tell the truth, that will come in. In this particular case, I just don't know. I don't know what the law is going to be there in Arizona, so I don't want to guess and then be wrong. So I'll try to find out, because I'm curious about that too. Go Duke basketball. Why even prosecute when she is is already serving multiple life sentences? Good question, but I think there are a couple of reasons for it. One is there's always the possibility that there will be a reversal and that she'll get off from something that happened elsewhere. If that happened and she is no longer serving a life sentence in Idaho, maybe she'll be serving a life sentence in Arizona. And I think the second reason is just a sense of justice and fairness. If you killed one person and you're convicted for that, that's appropriate. But if you killed another person and there's no penalty for that at all, there's a sense, particularly for the victim's family, that justice was never done, that there was no consequence. Nobody really cared about what had actually happened. All right, Wendy asking me, will the police from Charles police interview be called? I would think yes. If they're still serving there, that yes, they would be called, or other people to summarize it. I would think yes. Do you think Lori will call Chad as a witness? I don't know, but yeah, probably. Probably. I'm going to go with a yes. Boy, that would be quite the event. Do you feel like more people are wanting to represent themselves? And by the way, let me throw out one other thing. Chad might not be relevant, but I think she could probably, if she knew what she was doing, think of a way that his testimony would get in. They considered apparently charging him with these Arizona cases and concluded we just don't have the evidence to rope him in. So there's evidence that they think they have against Lori that they don't have against Chad. That means he's not as likely to have information to present to the jury. But there are some things like, for example, the fact that they were putting something into the storage unit together, that kind of thing, and that she probably could find a reason to bring him to trial. But there might be a motion from the prosecution saying we don't want him at trial and we don't think he has any legitimate purpose for being here. He has nothing to say about this case. All right, Jenny wants to know, do I feel like more people are wanting to represent themselves now more than ever? I don't, interesting question. I guess I don't have any statistics on that. It's hard for me to answer that. I don't know that it's true in general or whether it's just these two cases that we have seen most recently. And these aren't the only ones. Obviously, there have been other well-publicized cases recently, but these are the two we covered here on the channel. All right, looking for verified vegan asking me if during the trial her behavior seems, sorry, my glasses, I almost got my new glasses today, but I went to pick them up and they had, there was a mistake, so they have to send them back. Okay. If during the trial her behavior seems more unstable, can she be deemed unfit at that time? Theoretically, yes, I think that could happen. If she was deemed so incompetent that she could not stand trial and she needed to be hospitalized immediately due to behavior in the courtroom or outside the courtroom, in theory, I think, yes, that could happen. I don't know if it's ever happened before. Probably somewhere, somebody, it's probably happened for that. So I'm looking to have to be able to read the questions. My glasses have to be in exactly the right spot, or I have to look really snooty like that. Those are my two options. Yeah, Lee T talking about Justin Lum with Fox 10 Phoenix, who has done a remarkable job covering these cases. Really well done. Sharon Hutchinson, do you think Lori will subpoena Chad? I would not be at all surprised. In fact, I'm going to go with yes. Bella, if convicted, could she claim ineffective counsel on appeal? Well, no, because she's waived her right to counsel. So she can't claim she herself was incompetent as counsel, that she was, ineffective. She can't claim she herself was ineffective counsel. I don't think that will be permitted. So how come she can decide not to show up in court? Why isn't she forced? I don't know. I found that really odd too. I don't know. Did she just roll over that morning and say, I'm tired, just don't feel like it? Not until I've had my coffee, and she missed the bus. I don't know. I found that really strange too. All right. Looking for question marks, and one from Mardella. What about sidebars? Interesting. I guess, well, first of all, she's not going to be able to be chained, I would think, because she's going to have to go up for the sidebar, because those are not just to be kept from the defendant. That's not the point of them. The point of them is to be kept from the jury. So if they need to have a conference outside the hearing of the jury, maybe what the judge would have to do is every single time dismiss the whole jury, have them leave, then do it. If she's chained, because a lot of times there's an ankle bracelet, but maybe they can do a stun bracelet or something like that, so that she can literally walk up to the front. That would be really interesting. I think in fatness, I think about it, I think that's how they would do it. All right. Mango Tango lives in Phoenix. How do I figure out what courtroom the trial will be in to attend it? I assume that's public information. Probably yes, but I doubt we'll know that until a little bit closer to the time. There may be some figuring out how many they're going to have, how much room they need. There might even be an overflow room. If only the Delphi case had that. What a difference things would have been. All right. So Marley can't put in question marks on her laptop. Oh, well, that's frustrating. Okay. I'll try to look for your question if I spot it. MB, are you able to clarify the charges? I thought it was conspiracy to commit murder. Yeah. So I think you're looking at their charges for Brandon Boudreaux and their charges for Charles Vallow. So I think that's what the difference is, that you're seeing two different things. And I think that's why there is a difference. I think it was conspiracy. What did I have down here? I'm pretty sure it was conspiracy on murder conspiracy for Charles Vallow, attempted murder of Brandon Boudreaux. That's what I had down. And we'll definitely flesh all that out, get really specific closer to the time of trial, so that we know exactly what the charges are and what the elements that will have to be proven are. So Laura asking me, if convicted, would she serve her time in Arizona or Idaho? Probably Idaho, because after this conviction, she would be sent back to Idaho to serve her time there. And then if she finished that, she would be sent back to Arizona. But in that it's a life term, there's no finishing it. So there's probably no realistic way that she ever comes back to Arizona to serve her term. But she continues to push for a speedy trial. So she was asked about that today and said, yep, I can be ready. I'm totally fine. So it's going forward fast. There's not going to be a big delay. Kookie asking me if she already in for life. Yep. Or if she would win, can she get out at some point? No, not unless it's overturned on appeal. The sentence is that she doesn't get out ever. If it's overturned on appeal, then maybe she would get out. Maybe it would be sent back for a retrial, or maybe there would be some fundamental error that would completely cause it to be thrown out. But that's not very likely in this particular case, I would say. All right. So I have a few more people to thank, and then we'll call it a night. We've got Shards of Words is a new member. Dr. Vonda K is a new member. And Jackie P, 1954, gifted 5 lawyerly memberships. Thank you for doing that. I appreciate that. And that's why we have so many new members. So thank you. Thank you to all of you. And Lee T has been a member for 3 months. Welcome. I'm glad to have you for 3 months. And talking about Justin Lum, I definitely follow him, and he's been reporting from the courtroom, which means he gets some early information on that. Also, by the way, follow me on Twitter at LawyerLeeW. I'm trying to do breaking news on this case so that people can follow it. because this is, I think, going to be quite the case. Cat Artist asks a good question. How are they going to find a non-biased jury? And the judge is worried about that too. The judge even said something about, I think jury selection in this case is going to take a while. I think it's going to be a little bit longer than normal. And he's probably right, because there's so many people who know about this case, who know about Lori Vallow Daybell, who know all the history, who know that she's been convicted in Idaho, know why, and even know details about Brandon Boudreaux and the Charles Vallow cases. So they are going to have a hard time finding a jury that, and remember, they don't have to have never heard of the case. They have to have not formed an opinion or be willing to set their opinion aside. You know, from the Delphi case, I don't agree with that being one of the measures, but typically that is a measure. As long as they say, I could be fair and impartial, then even if they have an opinion or had an opinion, if they can set it aside, they're allowed to serve as a juror. But these are going to be hard, and it's going to be especially difficult for Lori Vallow Daybell because she's never done anything like pick a jury before, and it's going to be a weird, strange procedure for her. It's going to be hard to keep track of all of the people. There may need to be some kind of answers from them in a jury questionnaire. I don't know if the court will allow that or not. I personally am a big fan of juror questionnaires, but it's going to be really different. And a lot of the witnesses, a lot of the jurors may feel uncomfortable giving that information to the defendant, but that it will have to be given to the defendant so she can make a good call about each juror. It's going to be a very, very strange event. Thank you from Carrie and Lute's channel. I appreciate that very much. So, all right. Well, I will look forward to seeing all of you on Monday at 7 p.m. Eastern. I am hoping to do a video over the weekend, but I can't make any promises. I'm always saying I'm going to do a video over the weekend, and then I can't get it out in time, but I'm hoping to. And so be sure to keep an eye out for that. And I'll probably drop something into the community post too, if I'm able to do that. So I will see you Monday at 7 p.m. Eastern. Wait, stop. And thank you to our mods, Marlon, Mama Pinks, and Denise Pelton.